Sorry.
Good morning, everybody. Welcome to day 2 of hearing stream number 3, dealing with the rural zone. This is session number 1 on day 2. My name's David McMahon and I'm the chair of the independent panel. We've got the full panel with us today. Don't let that worry you.
Great.
We're all friendly. Yesterday, just by recap, we heard from the council officers who presented their section 42 report, principally Mr. Horrell, and he had a technical witness, Ms. Chambers, who assisted him. That took up most of yesterday morning, and then we heard from a number of submitters yesterday afternoon right through to around 5:30. So you're the first cab off the rank on day 2 as far as the submitters are concerned. And so it's Mr. and Mrs. Tomlinson, isn't it?
That's right. Yes, Kath and David. Yeah.
Well, do you have any? We've got a copy of your original submission on the laptop. I've read that. Do you have any additional material that you're going to present?
I'll get it to you afterwards,
Yes.
so we don't rustle through papers.
Yeah.
And but
Yeah.
we do have a presentation.
Okay.
Screen.
Difficulty with that is that not having the material in front of us.
It's on the screen,
That's on the screen.
and then we'll give you a
As
copy.
long as we don't have to take notes.
No, you don't have
Any
to.
notes.
No,
We'll give you 7 pages of notes afterwards.
Thanks,
Okay.
Hey,
Just don't assume that we all know everything. I'm the only member of the panel that's not Wairarapa based. I'm based in Wellington.
Mhm.
So tell us about your concerns, your property, that sort of thing. Give us the context.
Yes.
Great.
Yep.
Okay, I'll just get my presentation
Is there a? Oh, yes.
presentation up.
Yeah.
Okay. Okay.
You're welcome to remain seated. It's completely up to you.
And,
That's the function.
good morning. I'm Kath, and this is my husband David, and we thank you for the opportunity to speak with you today. We've raised our family here in the Wairarapa, but have lived here for many years, work here, and are connected with many in the community.
I'm David Tomlinson. For the last 40 years, I've been a building contractor constructing mostly houses on lifestyle and rural properties around the Wairarapa. Before that, I worked for my father and grandfather, who are both land surveyors, with my grandfather setting up one of the first land surveying businesses in the Wairarapa in 1948. I've lived on lifestyle blocks for 50 years, currently living just 7 k's east of Marston for the last 26.
We're really heartened to see in your report that the officer's recommendation is accept in part quite a number of submissions. We take this as an indication that you, the decision-making panel, are open to making some changes to the draft plan.
We are particularly concerned about the proposed plan for all new Marston lifestyle blocks to be formed in one area, being Gordon Street, Milford Downs and Ardsley Lane, and the minimum lot size being just 0.5 of a hectare. To us, quite frankly, this seems ridiculous. In Charles Horrell's September report, he states there is no intention by MDC to pipe the sewerage overflow from the 300 plus lots, being the 250 new and the 50 existing that they're going to coexist with, into the Marston Town Sewer. This completely contradicts the stated aims for environmental sustainability that the proposed plan is supposed to be aiming for. The great majority of the land earmarked is classified as highly productive, and this was reported in Ag First Soil Report, which also goes on to say that the area has heavy soils, poor drainage, very wet in winter and a high water table. It astounds me that there was no soil report arranged on this area until July 2024, a 3.5-year delay, and I would have thought for good planning, soil suitability would be the first thing to be ascertained. Greater Wellington Regional Council are actually responsible for all septic tanks in the Wairarapa, and have they been consulted? Is there a report available? Have they given the okay to proceed with 0.5 hectare lots en masse with 300 dwellings, not connected to the town sewer. It would be completely impossible for individual septic systems, as is proposed, to keep effluent within the boundaries of each half-hectare property en masse during heavy rainfall events. Previous district planning had good reason for selecting 1 hectare minimum lot sizes due to the fact they considered it was a minimum lot size to be able to manage unserviced lots.
So how does Milford Downs look as an option for the half-hectare proposed sites? There are probably a few, but not many sites in Milford Downs that could be successfully subdivided to half a hectare. These properties have sewer overflows that are connected to the town sewer, so wastewater can be managed. In Milford Downs, there are currently 2 test cases being considered for subdivision, and these are in the process of being notified. I have it on good authority from one of the current owners seeking consent that he has received 10 objections from his neighbours. Most of the properties in Milford Downs have been built in the middle of their 1 hectare site. They are built on the only practical house site on that land due to the topography, which is rolling hill, so are not able to be further subdivided exactly in half as is proposed in the draft plan. Subdivision of Ardsley Lane is a lot more problematic than even Milford Downs. Ardsley Lane cannot be subdivided in the manner specified for the following reasons. Ardsley Lane lots are also mostly 1 hectare. Unlike Milford Downs, Ardsley Lane lots are not plumbed into the Masterton town sewer. On the titles, there is a covenant with a designated building platform. Right. There are also existing covenants in place which prevent subdivision unless all lot owners agree to lifting a covenant.
So between these 2 areas, Ardsley Lane and Milford Downs, how many extra sections are actually available? We think 2 to 3, not the 42 as indicated on the plan. We believe the number of lots proposed for the lifestyle rural zone in the draft district plan are misleading and unattainable. Different options need to be assessed. It is beyond unreasonable in Masterton to only offer up rural sections that are half a hectare concentrated in 1 area of town and that there are likely to be serious sewage issues in winter. We note Carterton District Council and the South Wairarapa District Council couldn't find themselves at Gordon Street in their particular areas for very good reason that it makes no sense. To move forward and enable us to make sensible rural planning decisions, we need to first look back at some of the past Wairarapa rural planning. Pre-2012, before the first Wairarapa combined district plan, there were areas designated for rural living on less productive land on lot size of 1 hectare minimum. All the discussion during the lead up to the first 2012 combined district plan was that the minimum lot size was going to change from 1 hectare minimum to 2 hectares minimum. And then everyone was completely blindsided when the plan was changed to a 4 hectare minimum. In 2012, the plan changed from 1 hectare to 4 hectares minimum on both high and low production land. And now we are looking at a proposal to shift to 40 hectares with an offset of 300.5 hectare lots en masse in 1 area of Masterton. Back in 2012, when the decision was made to go from 1 to 4 hectares, it made no sense then, and it still doesn't. In Charles Horrell's September report on rural zones for the plan, he agrees that 4 hectare rural lots are too large to support efficient use of rural land. To show the effect of such planning, I will explain a case. I missed it.
Okay.
To show the effect of such planning, I will explain a case study of an area of land where I live. This slide shows a current existing elevated rural cluster of lifestyle blocks on rolling land, which is not particularly highly productive, located 5 minutes east of Masterton, the Lees, Pakaraka and Strombo Road area. Let's look at the impact of rural planning rules on a property this size. We have 15 neighbouring lifestyle lots covering a total of 25 hectares with an average lot size of 1.67 hectares. We currently own 6.3 hectares, the equivalent land of more than 4 of our neighbouring properties put together as one. And although before 2012 we could have subdivided our property into 6 lots, we currently cannot subdivide it all under the present or proposed district plan. Perhaps we could compare this area of rural land with another plot of land which has recently been subdivided and put on the market for sale. It's a 20-lot subdivision with the minimum subdivided under the current district plan with a minimum of 4 hectares, which has taken up 125 hectares of land. It's basically a farm, has been taken up for 20 lots. This is an extra 105 hectares of land that has been fragmented. 1 hectare lots would have only taken up 20 hectares of this particular property, leaving 105 hectares intact to continue farming.
So in the Wairarapa, there are lots of lifestyle properties under 8 hectares, presently not able to be subdivided, surrounded by 1 hectare lots. Land to allow more infill without taking up more highly productive land. Case there. Rather than continuing to swallow up large amounts of land in 40 hectare parcels, as is proposed, infill subdivision is the only viable option that should be being considered for the entire Wairarapa. Your decision over rural lot sizes has large implications. The larger the lot size, the more land will be swallowed up. People have deep pockets and will still afford the cost of 40 hectares for rural living. You will not price them off the market. Recently, a bare 1 hectare Masterton lifestyle lot sold for more than $900,000, purely because of a lack of 1 hectare lots available. People want them. 1 hectare lots are sensible because they are many clusters of existing rural subdivisions across the Wairarapa that could be further subdivided in that way. And what is the demand for rural dwellings? The proposed plan says that we need about 90 a year across the Wairarapa, as Masterton has the highest population and is the main service town for the Wairarapa, with a majority of schools, hospitals, work opportunities and so forth. We need to ensure that there is planning capacity for the demand. Only allowing the choice of half hectare blocks in one area is severely limiting for the reasons highlighted. So we need to look for capacity in other areas. Currently, government is recommending councils plan for 30 to 50 years. This is surely the time for Wairarapa planners to also be visionary and get organised for population growth. If we do not, the Wairarapa region will lose out to other regions. The growth and vibrancy we have seen for the past 10 years in the Wairarapa is due to 8,500 additional people moving to the Wairarapa, bringing with them skills, business, and providing economic growth for our region. We need to continue this momentum to enable Wairarapa to continue to prosper. Over the next 30 years, Greater Regional Council Growth Framework projects Wairarapa will be a home to an additional 22,000 people. Clearly, 4 hectares minimum size hasn't worked for the Wairarapa for the last 12 years. The answer is 1 hectare, and it being only rural infill in subdivided areas that are already subdivided. We don't want the further loss of land. We certainly don't want 40 hectare spread.
This is an aerial photo of the area that I live, and it just makes sense to infill these areas rather than, there's 2 more lots on our property alone, and there's plenty of properties around that are like it, rather than the march across farmland. It just makes total sense to infill. That's what they're discussing in town too. That's where they're wanting to go, to use the land that's already there, basically. Just to recap, it's quite obvious that many parts of the proposed district plan have not been well thought through, and that an appropriate level of planning is lacking. The problems with planning in the Wairarapa began with 2012 combined district plan changing minimum lot sizes from 1 hectare on less productive land to a blanket 4 hectares everywhere. We have seen land creep everywhere. Whole farms turned into lifestyle blocks. We don't believe the information provided in the draft district plan is detailed or thorough enough for you to make informed and sound decisions. We believe that you need to find out how sewage will be managed on unserviced 0.5 hectare lots en masse. Is it physically possible? Will Greater Wellington Regional Council accept 300 lots of 0.5 hectares in one area? Find out the actual number of lifestyle lots that actually can be subdivided in the rural lifestyle zone. This is more likely to be close to 100, not 250, which is still 100 short of the 350 required for the next 10 years. Find out how many 4 hectare lots have been subdivided in the last 12 years in the Wairarapa so that you know how many original lots might be available for infill subdivision. The amendments required for the Wairarapa Combined District Plan sub R4 to be amended for all of Wairarapa. Allow infill rural subdivision at the lot size of a minimum of 1 hectare for the reasons previously specified. Allow blocks under 8 hectares to be included in being able to be subdivided, as these blocks have been excluded from subdivision when the 2012 Combined District Plan changed from 1 to 4 hectares. Gordon Street and Ardsley Lane to be under the same minimum 1 hectare lot size, not 0.5 hectare as is proposed in the draft plan to manage sewage discharge on site. There's an expectation from the people of the Wairarapa that we will get a plan that is sound, sensible, practical and workable, that moves the Wairarapa forward as a whole in a positive and visionary way. To the committee signing off the Combined District Plan, please seek the appropriate expert advice on the many areas of concern we have raised today. Now is the time for you to make the right decisions for the Wairarapa. Clearly in the 2012 first Wairarapa Combined District Plan, that didn't happen with the change from 1 hectare to 4 as the minimum lot size. Your names will be alongside this 10 to 12 year plan for many years to come. The contents and direction are your responsibility. Thank you for your time today.
Thank you both. Oh. And have you emailed Ruth a copy of that presentation?
Yes, I can do that, and I'll give them.
Reason I asked that is that we'll need to put that on the webpage so it's available.
Right.
To view.
Yeah, we'll be doing that.
Thank you.
Mail it to Ruth.
Yes,
Yep.
thank you.
Thank you. Okay.
Yes.
Mr. Thompson, you've raised a number of issues here. Thank you for that very comprehensive presentation. There's a number of matters that the officers will want to respond to, and we have a process for that.
Yes.
They will provide a written response to those matters within 15 working days of the hearing closing. That'll be available for all parties to view.
Yeah.
We'll have some questions for you, and I've got some context. Before I do that, I'll just go to my panel, starting with Craig.
It's just the projection is for around 90 lifestyle blocks throughout the district. And
yes.
I think it's 35 for Masterton.
Yeah.
In your experience and what you've been, do you believe that demand is possibly underestimated, or where do you think?
Possibly, because we're the main service town, it would make sense for it to expand at a greater rate than when you look at the State Highway 2 that we've come down this morning, the busyness of it and the schools and the hospital and all that sort of thing. We expect Masterton to be higher than that. But.
And there is quite a frustration. A number of people living south are moving to Masterton because of the commute issues.
Yeah.
And getting their kids, getting to work and things.
Yeah.
And elderly people moving are more likely to want to live in Masterton. So it depends on who's moving to our area.
But just the sheer numbers that we've had, the 8,500 people in the last 10 years tells you that the numbers are probably...
They will increase, and people can work from home, so they don't need to live in the cities.
Yeah.
Thank you, Craig. Any further questions? Alison?
Got a couple.
Yes, please, please do.
You talked first about allowing subdivisions in an existing subdivision area, okay?
Yes.
Taking your area at Leeds Pakaraka Road.
Yep.
If there was a block that was surrounded by those that's 10 hectares, and then you subdivide all the other areas, so you end up with a 10-hectare block in the middle that couldn't be subdivided under your rules, how would you feel that would sit in your argument?
Well, that's quite a good point. I mean, I'm not quite sure what the actual number should be, but what I was what I'm trying to get through is that we're talking that it's in the submissions, it said that it was for lots 4 hectares and under, and then suddenly it said that it has to be under 4 hectares to be subdivided. So I'm just trying to expand that a bit to collect these properties that are stuck in no man's land between 4 hectares and under 8.
So your 8's an arbitrary figure.
It is an arbitrary figure, yes, yeah, but I take your point. I mean, I'm not quite sure.
End up with an isolated island in the middle of.
Yeah, well, that's
But
basically what we have. We have a 6.3 hectare lot surrounded by 1 hectare lots. So, and we're getting older. We've been there for 25 years. We want to be there for another 25 years, and we've always thought we could end up with 1 hectare in our old dotage. So, and that's what
Not that old yet.
that's what we bought into.
And that's the other thing. The other thing is people have bought into something and then the rules change on them. People are now,
Drastically.
particularly in Milford, they've bought their lifestyle with their land. Have they been asked, do they want half
Yeah.
the hectare lots?
The other interesting thing is I was talking to one of the main surveying companies in Marston yesterday, and they say that nobody has been to see them to hear what they think. What they think. And they've just given up because the same surveying company spent a lot of money because they were horrified with the 4 hectare minimum. They knew it was wrong. I think everyone in the room will say it was a bad decision 12 years ago to make.
Oh.
And he tells me that he has not had one person in the door to ask him what he thinks.
Thank you. So the next question is, you're against the 40 hectare minimum. That's it. Did I hear you right?
Yes. Well, just from the point of view that if you imagine that this, for argument's sake, a 1 hectare lot on Marston has sold for over $900,000, a bare piece of 1 hectare. People will still spend that money. Well, for example, with that lifestyle lot of 125 hectares out at Carterton, their proper prices are 350 to 500. So 14 hectares up to 14 hectares. So people will.
I'm trying to think along the lines of protect rural land for primary production.
Yes.
Yeah.
In your view, what would be a lot size if I had a 1,000 hectare farm and I wanted to cut it down? What would be a block that you would suggest would still be a viable size to produce something?
Interestingly, I was thinking about this morning. Chris Charles Horrell's saying that an economic farm is 200 to 300 hectares, and you'd almost need to go to 100 to stop but you've got to have enough property that can be put into 1 hectare lots to feed the need for lifestyle without chopping up 4 hectares at a time land going everywhere. Yeah, does that make sense?
Yeah, no, it's I'm just trying to make sure I
Yes.
understand how you.
Yes, yeah.
And the final question I've got is the 1 hectare minimum that you're talking about.
Yes,
Are you arguing that on the basis that
containing sewage, basically.
So you don't believe that the hectare you can.
It can't.
Not in a wet Wairarapa winter on heavy soils.
Okay.
Yeah. I've been on many sites. That's what I've done for 40 years, is build houses on lifestyle blocks.
And if you think of putting a house on a site and then the septic fields have to run away from the site and
20 metres off the boundaries, and it just
doesn't work.
the numbers don't work. Yeah. So we're trying to save you before you get egg on your face, really.
Any further questions on this?
No, just a statement really. Thanks for sharing that information from your viewpoint too, from
Yeah.
having done buildings and obviously a planning background. Thank you.
Yeah, I mean,
We're just passionate about the Wairarapa and we actually want the right decisions to be made for us. We just don't want to, it's just a huge frustration that it went from 1 to 4 last time. And we just don't want to repeat that same sort of mistake, I guess.
and I think also lifestylists can get a really bad rap that they don't look after their land. And around us, we've got someone farming, and they've got an onion crop all over their small. How much land?
Yeah, 1.7 hectares. They've probably got a hectare of onions. And we've got another neighbour above us that's got 1.3 hectares. And at the moment, with the lamb drop, he's got 22 stock on his 1.3 hectares. So,
It's not a bad.
and we turned up there to 6-foot thistles on our block 26 years ago. So
And people have
it's
planted
not all
lots.
bad, but 1 hectare, like we just drove rural this morning, and I think 4 hectares is a bigger problem for people on lifestyle. It's a huge problem for people on lifestyle. They don't look after it properly, whereas a 1 hectare is more contained, more manageable, and they can have their stock if they want to, but not if they don't. And yeah,
And farmers retiring to town, when you ask them what do they want to buy, they want a small piece that they can look after. They know how to look after land, but they don't want 4 hectares.
yeah.
Thank you both. There's a couple of factual matters I just need to comment on. I don't have a question for you. Just in terms of consultation, all residents, survey firms, etc., were consulted in relation to these provisions, and they were.
I was talking to the owner yesterday, so here's the new owner, but yes, yep,
This was something that the committee was very, very keen to
yes,
happen.
yep,
And there was a draft plan before the notified plan.
yes,
And there was a 3-month period for comments on that.
yes.
The responses from the surveying community were pretty few and far between. And
Well, I think they've given up that you'll just choose what you want to choose. I think that's
That is
the
the
Thomason, this was an opportunity for people to make their thoughts known
yes,
prior to the plan being notified.
yes, yes,
And the committee received information from a variety of sources.
yes.
All I'm saying is factually, there was a paucity of information from the surveying
Community.
Yeah.
Yeah. Well, that's great.
Disappointingly. You raised another couple of questions about Greater Wellington. We get the benefit of their presentation yesterday.
All right. Yes. Yes.
They raised some concerns about disposal of wastewater.
Yes.
In relation to drinking water areas.
Yes. Yes.
They advised us that their own district plan allows a low-level consent for the discharge of wastewater as a controlled activity.
Yes.
But they did express a preference for an increase in the allotment size from 0.5 to 1 hectare.
Right. Yeah.
At the same time, in a different extreme, the same council discouraged this panel from moving into greenfield development. High intensification within the township.
So you're stuck. Yeah.
We're receiving competing information all the time. We need to balance that and see.
Yep. I totally understand that.
Finally, you just raised a question about what's happened since 2010 and 2012 to go from 1 to 4 and then this 40 hectare limit. What's happened is a national direction called the National Planning Standard for Highly Productive Land. It came in halfway through the council's preparation of their draft.
Yes. Yes. Yep.
That plan, the council was looking to make provision for Lifestyle Village in an even-handed manner.
Yes.
Across the district, not
Yes.
have a provision for Masterton and then a provision for South Wye and
In Carterton.
what came in was a requirement for not just land use categories 1 and 2, but 3 to be protected.
Yes.
And that created a need to relook at the strategy, and it resulted in an inability to define a lifestyle zone for those 2 districts. And it left the lifestyle zone for Masterton because the existence of land use 3 wasn't as extensive in that district.
That's correct.
That was a big change in strategy for the panel.
Yes.
For the council, as a result of national direction. So the direction that Oral's been having to respond to is a direction that requires the protection of productive rural productivity. But at the same time, trying to find an outlet for rural lifestyle. And
Yes.
that's the real issue for the
Hard pace, yes, yeah.
And so you've added to the puzzle. Raised some nice questions that I'm sure Mr. Horrell and his advisors will respond to. So thank you for that.
No, thank you for the opportunity.
I should say, the other thing is the combined Wairarapa plan, probably one of the first in the country that's going through a full review since the HPL NPS was developed. So there's a lot of focus on this particular plan. There's not a lot of previous
There's
to go on.
yes.
So
You're groundbreaker, so it's important that you get it right.
absolutely. Yeah, I couldn't agree
No
more.
pressure.
Yeah, no pressure, guys. Yeah,
Thank you for your presentation.
yeah, lovely.
Right,
Thank you.
Cheers, guys.
Okay. We have Mr. Rendell.
Yeah.
All right. Kia ora, Mr. Rendell.
Kia ora tātou, ngā mihi nui kia koutou katoa. My name is Steve Rendell. My PowerPoint slide is not up to the previous presentation, but there you go. So this is just a little bit. I live at 66 Chamber Road with my wife Audrey. It's getting a bit closer. This is the area we're talking about here. So obviously, Chamber Road outside Masterton. This is Serbia. This is the current the area that I'm speaking about. Our property is 4 hectares. We look after 2 dogs. I wouldn't count as working dogs. One is about 13, the other's blind and it's got 3 legs. 2 donkeys and currently 15 ewes and about 19 lambs help keep the grass down. As you probably have seen from my written submission, I'm really presenting to an extent neighbours at numbers 52, 78 and 102, which is the southern end on the sort of western side. Our submission relates to what we believe is an inappropriate zoning of the properties on that western side, southern end, is general rural in the proposed plan. We believe these are more appropriately zoned rural lifestyle zone. I'd like to cover the following points: consistency with the plan, the nature of the properties, the historical background of these blocks as I understand it, and avoiding anomalies in a brand new plan. Our view is that these properties will never meet the criteria set down in the plan for general rural properties. They will never be primarily used for primary production. Most of them, they're blocks of 4 hectares or less. I think some of them are 4 different titles on one property at the end there. They are well cared for and grazed appropriately, but they are nowhere near economic units. The stock largely keep the grass down. There's a reason why I'm the only person in front of you of the group that we're representing. Everyone else has got day jobs they've got to be at. They obviously will never reach the minimum size in the plan of 40 hectares for general rural blocks. Even if they were to be sold to a single buyer, there would be nowhere near the 40 hectare limit. And to us, there is an obvious solution, which is the proposed plan provides the following description about the intended rural lifestyle zone, that these are areas identified within the outer edges of Masterton, where there is a higher concentration of rural living facilitated through smaller allotment sizes. There is a capacity to accommodate new rural living opportunities, and there's an absence or limited accessibility of reticulated services. Those are the words obviously in the plan itself. These actually, they very accurately describe the current nature of the properties I'm talking about. And the proposed then furthermore states, and I quote, subdivision, use and development of the rural lifestyle zone is expected to provide a transition from residential areas to other rural zones, while retaining a sense of spaciousness and prevailing rural character. This reflects the use of land and dwellings for residential activities and small-scale rural production activities in a rural setting. And I think that transition zone and point is really what we're talking about here. On the opposite side of Chamberlain Road, which is it's marked helpfully future urban zone. The plan talks of the rural lifestyle zones providing a transition from residential to other rural zones, and this makes perfect sense. There is, there's considerable potential for reverse sensitivity if properties on the western side were to actually become primarily used for primary production, while residential development takes place on the eastern side across the road. The sound of roaring stags, for instance, currently takes place beyond the helpful transitional buffer of a rural lifestyle block. That's the area to this up. In reality, a deer farm up here, and from March to May, it's pretty noisy, pretty interesting, and I imagine newcomers to a new settlement might be somewhat startled about the racket coming from there if they were not aware of it. Now, by way of historical context, and I hope I've got most of this information correct, it's worth noting that since the establishment of Masterton, this area has been designated not really for large rural land parcels, but smaller blocks. Back in 1854, there was an expectation that people with an urban block would also have a so-called suburban section, I think of around 40 acres, around 16 hectares. These subsequently evolved or devolved to the 4 hectare, 10 acre special rural zone blocks that existed before this plan was reviewed. I make that point to emphasise that there is a history of this land being treated as something different than rural or urban. It is in that middle ground. Now, I've heard the issue of highly productive land being raised, and as we've considered this land is categorised as highly productive, but I don't think that can be a single determining factor, because I'd point out that the land in the future urban zone is also categorised as highly productive. Finally, I would leave you with a question that why in the process of doing the plan, which is taking a long time and there's a lot of effort's gone into it, by ending up with a plan with already built-in anomalies with properties that don't fit the criteria under which they are zoned. The solution, I think, in this area is to simply follow the criteria in the plan, which would lead to this being the rural lifestyle zone. This is precisely what it is now and what it will continue to be. So I'm happy to answer any questions you might have. Thank you again for the opportunity to speak.
You're one of 9 individual submitters that have sought some zoning changes from general rural to lifestyle. So I think we've heard from 3 so far. So you being the 3rd. I'll just check with my colleagues and see whether start with Craig.
Thank you, Steve, for your presentation. Now, the 4 properties you're here representing.
Yep.
What would be the current average lot size of those?
So I think it's about 4 hectares. So we're talking about Hamish and Abby are up here. We're here. Phil and Jeanette are there, and then there's these. Charlie has got the 1, 2, 3, 4. They're 4 separate titles. I don't know the detail, but they would add up to probably a little less than 4 hectares perhaps. So I haven't spoken to these folks, but that's those that are severe. That 4 hectares, so I think that was the limit under as a special rural zoning.
There's another title. On your neighbours there, right in the corner. Is that another title there?
This little one.
Is that a title as well?
It's a separate, I'm not quite sure what the background to that is. That was there before we arrived. It's a single dwelling on a tiny little section.
Just on that top left of that circle, middle left, there's 4 blocks here just there. They're all,
The back.
you go
back.
up.
Yeah.
So they're all separate titles as well, or separate titles?
To my knowledge, they are. So these are all 1, 2, 3, 4, 1, 2, 3, and these 4 are all. This is, I think, is separate, owned by the same person.
Yeah.
I'm not sure what the status of these is, but that down the back there, that's the.
It looks like one title was shelter dogs.
Yeah, it does, doesn't it? Yeah, with the driveway coming up.
What about the one above, right at the top, that one? See,
That one? Yeah, he was, I can't remember what his preference was. I think he was more keen on it being future urban, which I think it was in the draft plan.
Yes.
Have you got the plan up, so? Got the aerial, do you want to know?
Try just one quick question is what's the zoning up on the eastern side of the road there?
This up here,
Yeah.
that is residential. I think that's where it's
The yellow is residential.
being developed.
Yeah, thank you. That's, yeah.
Yeah, that's right. That's it.
Charles, can you confirm that is the future urban zone is category 1, 2 or 3 land as well?
Yes. It is. C land is the future urban. During the proposed plan.
But that's using, was that through physical inspection or that just the maps that we've discussed previously?
That's using the same maps that have been used. The NPS highly productive land requiring those higher level maps to be relied upon.
Thank you. Any further questions of Mr. Rendell?
Dave, I'm not Steve, but perhaps I'm Charles. That block of land immediately below that circle, what zone is that?
Immediately below,
Yes,
in
there's a
between West
number of
Road.
acre properties in there.
So that is future urban zone. Directly below. I might just actually get up and.
You're talking about this one?
Yeah.
What's the trapeze?
Other slab.
Come up. Across there.
There's the future urban zone.
Yes.
Sorry?
Future urban zone.
Urban zone.
Mr. Rendell, thank you. Again, by the previous committee, you've raised a number of questions. Just going to give a couple of directions to the officer while you're present. We'd like a little bit of a background on Chamberlain Road properties, how they've morphed from the operative plan. I think Mr. Rendell was referring to a rural special zone there, through to the draft plan, which and then through to the proposed plan. So just a factual delineation of how this group of properties have morphed between those 3 documents. And secondly, and this is solely in relation to Mr. Rendell's submission, as relates to a number of things that have come through. The panel want to understand our land that's classified as LU 1, 2 or 3 can in some instances qualify for an urban type development, whether that's FUZ or LFZ. When I say rural, I mean a form of rural urban development, and in other instances not qualify in terms of the,
Yes.
particularly in terms of policy 310. And we'd like to understand how that policy can be applied to those different instances.
So would you like me to respond to the future urban question? Would you prefer the reporting officer for that hearing stream?
Well, you can, there was Solitaire, was it?
Future urban zone, yes, it was.
Yes. I think a joint response would be in order. Yes. This is just a thing that's come through over the last couple of days that's been troubling the panel, and we'd just like to understand what guidance the EPS HPL allows, provides in terms of the different zoning outcomes for land that is 1, 2, and 3. Yeah.
Nice.
Thank you, Mr. Randall.
Thank you.
And that would be the same question we'll answer
Down there.
the Nanatara Road.
Yeah,
border as well.
exactly.
Yeah.
Okay, the next submitter is a further submitter, Holly Hill.
Very old DP.
Oh, hell.
And I think Miss Dora is presenting. Oh, Miss Dora, you're online, and so it's
Good
Holly.
morning.
Good morning, both of you. Running about 10 minutes late. Apologies about that. Thank you for your patience. We have a copy of the legal submissions prepared by Minter Allison Rudd Watts on behalf of Holly Hill. Who's going to kick off?
Sure. So yeah, Kate Storer, counsel for Holly Hill, who is further submitter 78. She's the owner of 129 Hinakura Road, Martinborough, which is a 6-hectare block. So if you're happy with this, I can take you through the high points of the submissions that we filed on Friday, and then Ms. Hill can give you an overview of her property and the implications of the proposed plan provisions for it.
It's absolutely fine.
Thank you. So in summary, Ms. Hill's further submission supports amendments to the proposed plan to ensure that rural lifestyle subdivision is not inappropriately constrained, consistent with the outcomes and contemplated by the NPS HPL. Specifically, the changes that Ms. Hill is requesting relate to a minor change to Policy 6 and a more substantive change to Subdivision Rule 210 relating to a consent pathway for subdivision of highly productive land. So the difference between discretionary and non-complying. You'll hear from Ms. Hill about the constraints of her property and the implications of the rules for its efficient use. But in summary, part of her property is not suitable for productive use, and she wishes to retain a consent pathway to be able to subdivide it for rural lifestyle purposes in the future. And I think, I guess the key issue that comes through from the in the provisions and reflecting on the 42A report is that at present the rules are something of a blunt tool in as far as the general rural zone is applied to the majority of rural land in the district, regardless of its characteristics. The land in the zone is varied in character. Not all of it is used or useful for primary production. But nevertheless, at present, the provisions only provide extremely limited opportunities for rural lifestyle subdivision, regardless of the character of the land. Even with the amendments that Mr. Horrell is recommending, most subdivision of lots above 4 hectares will be a non-complying activity, regardless of its character or productive usefulness. It's submitted that this is not necessary to achieve the strategic objectives for the rural zone, which are aimed at prioritising the protection of productive capacity and then enabling lifestyle subdivision where it doesn't conflict with that production objective. And I've drawn the panel's attention at paragraph 12 to Forest and Bird and Whakatane District Council, in which the Environment Court made clear that what is the most appropriate rule in terms of section 32 needs to be identified with reference to the least restrictive approach, which still meets the purpose of the Act and the relevant plan objectives. So the court said, in considering what rule may be the most appropriate in the context of the evaluation under section 32, we consider that the correct approach remains that where the purpose of the Act and the objectives of the plan can be met by a less restrictive regime, then that regime should be adopted. Such an approach reflects the requirement in section 32 1B2 to examine the efficiency of the provision by identifying, assessing, and if practicable, quantifying all of the benefits and costs anticipated from its implementation. It also promotes the purpose of the Act by enabling people to provide for their well-being while addressing the effects of their activities. It submitted that the proposed rules relating to rural subdivision are not the most appropriate in section 32 terms because they're more onerous than is required to achieve the objectives. It's not necessary for all rural lifestyle subdivision of land above 4 hectares to be a non-complying activity. This places unnecessary constraints on rural lifestyle subdivision in circumstances where it will not have an impact on productive capacity. And I know in this regard that the section 32 analysis acknowledges that the cost to individuals will be high. So this is really a matter that we say should be scrutinised carefully. Secondly, and perhaps most importantly, the strategic objectives for the proposed plan need to be interpreted in a manner which gives effect to the MPS HPL. And I noted your comments earlier that this is one of the first instances where the MPS HPL needs to be applied, and there's obviously a bit of a paucity of case law on the issues, which does make it difficult. But I think we say that there is a clear direction in the MPS which needs to be followed. So the MPS sets the policy direction regarding the extent to which highly productive land must be protected. And to give effect to the MPS, what is inappropriate subdivision use and development must be identified with reference to the outcomes required by the MPS. And the point here is that the MPS doesn't just set a baseline for protecting HPL, it sets the whole policy direction. So it identifies what is inappropriate and therefore what is appropriate. That's reflected in policy 7, which states the subdivision of highly productive land is avoided except as provided in this national policy statement. And then clauses 3.8 and 3.10, the implementation clauses, identify the circumstances in which subdivision and development of HPL is not inappropriate, including where the applicant demonstrates that the proposed lots will retain the overall productive capacity of the subject land over the long term, and where there are permanent or long-term constraints on the land that mean the use of it for primary production is not economically viable for at least 30 years. Notwithstanding this direction, subdivision rule 210 only provides a discretionary consent pathway for subdivision of highly productive land if the subdivision is directly related to primary production, and it's that clause which is really the focus of our concern. So the 42A report records that the intent of this clause is to capture primary production subdivision for either orchards or vineyards that is not otherwise enabled by the minimum lot size. And then other subdivision, it would be a non-complying activity, for example, for rural lifestyle purposes. We say that's a clear indication that it is considered to be inappropriate in terms of the proposed plan. And so case law states that non-complying activity status means that the activity needs to be subject to a high level of scrutiny, meet a sterner test because of the likelihood of at least one adverse effect being more than minor. Yeah, I think that pretty much equates to inappropriate, and that is not necessarily the case here. So the effect is that even though subdivision of Ms Hill's 6-hectare property to enable an alternative efficient use of the non-productive part of it may be considered appropriate under the MPS HPL, it would require a non-complying activity consent. It's therefore submitted that amendments are required to subdivision rule 210 to ensure that the rule gives effect to the strategic objectives of the MPS by providing a clear consent pathway for subdivision of highly productive land that is not inappropriate or where it meets the exceptions, if you like, in the MPS. In addition, and separately, we agree with Mr Horrell that the rule needs to be amended to clarify that compliance with clauses 3.8 and 3.10 is only required in respect of highly productive land. As notified, the rule applied those criteria to all land, not just highly productive, which obviously is not required. So by deleting the line about directly connected to primary production, some further changes are required to avoid unintended consequences, in which non-highly productive land would be treated more restrictively. So we've amended those provisions in relation to non-highly productive land to be consistent with the policy direction in subdivision policy 6, which seeks to limit small lot subdivision within the general rural zone to only areas where the soil resource is fragmented and that does not compromise the use of the land for primary production. So at paragraph 26, I've set out the proposed amendments. Essentially, they would provide that subdivision as a discretionary activity where compliance is not achieved with the minimum lot size in subdivision rule 1. Land is not classified as highly productive and is either directly related to land-based primary production, or evidence is provided that the soil resource is fragmented and subdivision will not compromise the use of the land for primary production. So that's non-highly productive. And then for highly productive land, discretionary activity status where there's no compliance with the minimum lot size and the land is located on highly productive land and will meet clause 3.8 or 3.10. So that's the key change requested. There is one other more minor amendment, which is just to subdivision policy 6. This is a matter that was picked up in Mr Horrell's 42A report. As notified, it provided that all subdivision on highly productive land must be avoided. That is, as I've said, not what the MPS says. So agree with Mr Horrell's recommendation that the deletion of the reference to HPL in that policy should be undertaken. So at paragraph 30, I've got the text there, which just shows the deletion of that line.
Thank you.
So in conclusion, the proposed plan does not appropriately provide for the social and economic well-being of the owners of rural lifestyle lots who seek to use their land efficiently. Constraints on rural lifestyle subdivision in the proposed plan are both unnecessary to achieve the strategic objectives and inconsistent with the policy directions set by the MPS. Ms Hill therefore requests amendments to the subdivision rule 210 to ensure that there is a discretionary activity consent pathway for subdivision of highly productive land, provided that it meets the criteria for subdivision in the MPS.
Thank you, Ms Dora. Shall we go to Ms Hill and then we'll see what questions we have for both of you.
Absolutely. Thank you, Kate, and thank you everyone for hearing us today. So I don't necessarily have a visual presentation. I was just going to outline some of the features of our property, but I have incidentally brought up a map on screen that I can present via Teams, if that would be helpful for those in the room.
Yes, that would be good, please.
Excellent. Bear with me. Should be beaming to you now.
Yes, can you, oh, yes. Just wanted orientate.
Out. So for those familiar with Martinborough, this is the golf course here, actually, where my cursor is hovering. And the property that I own with my partner via our operating trust is this property here outlined in blue. And it is, as you can tell, bordered by many vineyards on this side and a few other varying sized lifestyle blocks on this side of Hinakura Road. The vineyards indicate that it is partially, at least, located on the Martinborough Terrace, which is generally well known and preserved as very good grape growing land. Our property is comprised of what I like to call two blocks, this front block here and a back block here, each separated by a shelter belt down the middle. We, in 2021, started undertaking our own assessments of the land to identify where we would most viably plant our own vineyard to make sort of wine for commercial use. And undertook a lot of testing at that time, and we identified a good block of land in this front block here, which I'll call the vineyard block. And ultimately we have planted sort of just under 2 hectares of vines in that front block there. The testing, however, indicated that there is very limited other land that would be suitable for growing vineyard, and principally that limitation is comprised in the way that the back block is composed. So I guess to walk you through some of those features, obviously the testing is one of the things that we did, and that was undertaking various digging expeditions throughout the property down to a depth of at least 1 metre in most cases. And we found that most of the back block at least comprises loam over a clay pan. And that clay pan is at a depth quite shallow, which prevents essentially proper drainage and root growth for vines. I understand that the clay pan is related to perhaps the contours of the land, which you can't necessarily see here, but the back block rises up towards the shelter belt here. And we think it had something to do with perhaps the earthquake over time that established this valley over here. That saw essentially a big sort of clay deposit in the middle of the property around here. And so it's the physical features as well that we kind of find as being a bit of a limitation on our ability to establish a productive vineyard in the back block. Those variable contours with the sort of rise and the hill coming up here. And also there is a sort of stream emanating from a perched water table that runs through the middle of the back block here. Both of those things contribute to various degrees of flooding throughout the year, which really limits the use of this part or this half of the back block in particular for planting a vineyard. There's also, I guess, an interesting feature to do with the size and shape of this back block and the shelter belts and the way that they sort of impact on any viable land planting. Effectively, what you'd be left with is sort of a slight L-shaped vineyard here in terms of plantable land. And that would necessarily be L-shaped because of the limitations that exist on this bottom half here. And then also the sort of buffer zone that would be required for both sort of tractor turning areas and also safe distance from the neighbouring shelter belts that would kind of provide competition in terms of root growth, but also would sort of compromise the ability to get a really good productive climate in that part of the property. So what we're left with really is an area of land that would probably comprise about 1 hectare for a vineyard, which we just don't think is a particularly productive use of this substantial piece of land at the back. We have considered other uses of the property. You can probably see here that, well, if I were to zoom in, you can see from the photo that it was recently cropped for hay. There's not a lot of hay that we necessarily get from that piece of land. So the other uses that we considered were orchards or olive groves, But of course, they are subject to similar limitations in terms of the depth of that clay pan and how it might affect root growth. Similarly, livestock would be an option, but it's not a very big piece of land. You'd be looking for at a sort of lifestyle block grouping of livestock. And there are also some barriers as well in terms of there's no freshwater supply back there. So ultimately, we're looking to sort of preserve an existing ability to potentially look to subdivide that block, and that's on the basis of our understanding of the NPS for highly productive land and the exceptions that introduces to that category. Those being that there are some long-term and permanent constraints on the use of the land for productive purposes. The size of the block is not significant relative to the sizes that we're talking about in the context of the NPS HPL. And there would not be a significant fragmentation of highly productive land as a result of this kind of subdivision. To the extent that there are reverse sensitivity risks, which I know is a very important thing in the context of the Martinborough Terrace and the Vineyard Soils Overlay, that we think could be addressed by conditions of consent and restrictive covenants. And really, we have been unable to identify long-term economic benefits associated with the status quo, which sort of just lead us to a natural conclusion that it's difficult to categorise this land as highly productive land, other than perhaps as a desktop assessment. And so I think the sort of key thing that we ultimately want to do is identify this land as not highly productive land and preserve that ability to subdivide simply on the basis of the impediments that we've outlined and the alternative uses that we've sort of considered and outlined. We think that perhaps it would be better used as a lifestyle block, similar to the lifestyle blocks on the other side of the road. Or alternatively, it could equally be used for commercial purposes. There are lots of vineyards with restaurants in the area, and a similar kind of facility could be set up, as I know has been done with some recent developments. So thank you for hearing me. I'm happy to keep the plan up on screen or take it down if there are any questions.
Just leave it up on the screen at the moment, Ms. Hill. We'll just see what questions there are of you and Ms. Dora on the panel.
Just one.
Right.
Yes, Ms. Hill, when did you actually purchase that land?
2019.
I thought it was. Thank you.
Alistair?
Yeah, thank you. You haven't made any comment about the Martinborough Soil Overlay.
Yes.
Yes, so appreciate that that's an existing overlay that applies to the property, and Kate might be able to fill in some details here, but the plan or the proposed plan, as we understand it, introduces a more restrictive approach to subdivision than the Martinborough Soils Overlay does, and we're seeking to preserve the position under the Martinborough Soils Overlay.
Ms. Dora, do you want to comment on that? There was a question that I had about whether the existence of the MSO changes anything.
Well, it does mean that subdivision rule 4 cannot apply because that has a criterion in it relating to the Martinborough Soils Overlay. I don't think that it makes a difference in terms of, well, it doesn't make a difference in terms of rule 10. And to the extent that it is directed to protection of primary production capacity, that also is kind of under the umbrella of the NPS HPL. So I don't think it makes a difference.
Okay. Any further questions? Ms. Dora, I've got just a clarification. I'm sure I understand what you're saying in your legal submissions, but I just want to check with you. Essentially, you're seeking change in activity status from non-complying to discretionary in subdivision rule 210, I think.
Yeah.
And you're also seeking some policy relief in policies P6, I think, against which an application lodged under Rule 210 would be considered. Is that it in a nutshell?
That's correct. Yes. In terms of sort of the effect, it is simply that at present the effect of Rule 210 is that you're only a discretionary activity if your subdivision is directly related to land-based primary production. So other types of subdivision, for example, for rural lifestyle purposes, would be a non-complying activity. We say that is not necessary, and it can be resolved by deleting that requirement for subdivision to be connected to primary production, and making the additional changes that are set out in the legal submissions.
Yes, and just for the record, you and your client are not seeking any change to the metrics associated with allotment size, are you? You're focusing solely on the activity status and the policy that backs that up.
Yeah, I think, yes, that's correct. And I think, and really that's because I think there is an acceptance that it is necessary for an application to be comprehensively assessed in the context of highly productive land, minimum lot size, and controlled activity status and so on, I think is probably not appropriate in this context, because it is necessary for the council to be able to assess the extent to which an application is consistent with the objectives and policies in the NPS and that have trickled down into the plan. So that's the reason for the focus on the rules and the activity status versus minimum lot size and, with the sort of threshold for controlled activity status.
Yep. Thank you for those clarifications. That's all I had on that basis. Thank you both for your presentation.
Thank you very much.
Thank you.
Mr. Mackay.
I am, yes.
How are you, Mr. Mackay?
Good morning. 9 copies of.
All right, thank you. Yeah, but an eloquent. Mr. Mackay, at some stage, would you be able to email a copy of the brief
Yes, I will.
on the web?
Yeah, good morning, everyone. I'm not sure what information you do have. We did submit some evidence a couple of weeks ago, but it doesn't appear to on the schedule. No.
First time I've seen this, man.
Right. No, that's new. That's just been prepared yesterday. But I did submit soil reports and some other evidence.
Okay. I'm not aware of that, but
right. Yeah. Yes.
Don't worry you. We'll track that down. This is your opportunity in the time to take.
Okay. Okay. Well, I'll just walk you through the background. And
please do.
So, my name is Ross Mackay. I'm owner operator of Dublin Street Wines. We're a very small vineyard on the south side of Martinborough. We have 3.5 hectare block planted around 2000 by the previous owner, James Brodie. It's always an unusual site. He could have planted it despite everyone saying, it's not a suitable site. It's not traditional soil type. It's isolated away from all the other vineyards in the Martinborough township. We don't have any other vineyards around us. We produce around 800 cases a year, and we don't have a cellar door. I say I have submitted 4 soil reports, all of which show that they're not free draining soils. It's basically clay. Just reads, when the bores were put in, they took so for the first 2.5 meters, light brown firm clay, and then a variety of stiff clays all the way down to even 50 meters. There's 2 bore logs done, first 23 meters, hard brown clay with gravel. And then I've also submitted the soils of the Wairarapa Valley 1974 report, which clearly shows that the whole south side of Martinborough is all the way for dozens of miles south of Martinborough is not on the kind of the old terrace which used to be protected. There was we currently have a special rural zone, which I'm sure we're not on that. We never were. I don't really know why we've been included in this Martinborough soils overlay. I don't think it's disputed really that we don't have those traditional soils. We've submitted three times to the council, but we don't really have any explanation why we were added. First, we weren't addressed in the Section 42A report, so I contacted the council, and
yes, Mr. Horrell admitted that he'd overlooked your submission.
Yes, so they eventually did. We did actually get to reply on last week, and it gave one reason, that the land is currently being used for highly productive crops. So, as far as I can see, the purpose in under GRUZ P7, there's in the proposed Wairarapa Combined District Plan, the purpose of it is to identify and protect land and buffer areas with the Martinborough soils overlay that contain have unique soil and characteristics suitable for high value crops. Not highly productive crops, are vulnerable to fragmentation of land, which doesn't really apply to us, and contribute to the social and economic and social well-being of Martinborough. We don't have a cellar door. No one visits our property. We're not vulnerable to fragmentation because we're so small. We're subdivided down to as far as we can go, so we can't be subdivided anyway. So I really don't understand why we would need to be on the soils overlay, or the purpose of it. I was involved a bit with the Wairarapa wine growers when they were consulting with Mr. Horrell, I think, and in their submissions, they clearly identified that there would be outliers. I suggest we are one of them by our very nature. We contacted Wairarapa wine growers. They have supported this application. They encouraged us to make it. I know they haven't opposed this. I spoke to David Eggleton, who was the chairman at the time, who did consult with the council. I spoke with him a few days ago, and he left those consultations that there was definitely outliers. There's more work to be done. That the soil experts should be involved, and that was his view. I'm not really sure much more I can add. I've not really been given information why we are here since we have been added. There are many other vineyards that aren't on it, so it's the Martinborough soils overlay, not the Martinborough vineyard overlay. So any happy to answer any questions.
We heard from the Wine Growers Association yesterday. I don't know if you managed to hear their presentation.
I clicked on the wrong link, so I thought it hadn't started. So I got the very end of it.
You'll be able to see the full presentation. It's been recorded. If you need to see that, we had a number of witnesses along yesterday, Mr. Aburn, or as the planner, and Mr. Lamb. You know him, Mr. Lamb, my grower, and we had Dr. Mel Soil. Good. Your property is one of 4 that have been submitted on in terms of seeking that being deleted from the MSO. Yeah.
I think they're all in the special rural zone though. They were previously
been under the operative plan.
I think we're the only one that has been added.
Okay.
There are several others in town and that haven't been added. So we are.
Yes.
Again, I don't know why they've not been added. You know, I could point them out. There's some quite large vineyards that are not on it, and very, very, very large vineyards that are not on it. So,
well, now's your opportunity to tell us.
All right. Well, there's around us. I think there's 3 or 4 vineyards not that far away in the south side of town, on Campbell Drive and Hawkins Drive. There's smaller ones, but they're still
So Campbell's Drive and
Hawkins Drive.
Yeah.
Be there. There is one fairly close to us, the old Thompson Vineyard, Shooting Butts Road. I think that might be pulled out actually.
Since it was sold.
Since it was sold, yeah. I'm not. It's on the map still, but I think it's gone. And they're kind of our size, they're a bit smaller. I noticed the Palliser Vineyard isn't on it. The one behind the cellar door.
There was discussion about that vineyard yesterday.
Right. There's the Nawaka Vineyard. There's 150 hectares of plantings down just off Lake Ferry Road now, which aren't, I presume they're new, but and the Cirrus Vineyard's not. But I suppose the point is there's lots of, probably the majority of the land in the soils of Lake doesn't have vineyards on it. You know, all up to the whole kind of eastern side of Tamina Road isn't planted. Swathes of land to the south, and they have suitable soil, presumably. It just seems odd that there's this tiny little island, and it would follow that really the whole of Martinborough area should really be on it or none.
But Mr. McCoy, the question I guess the panel have of you is, would your concern be met simply by removing the Martinborough soils overlay over your property? Would that solely?
It's kind of it. There's no. I have no issue with Martinborough soils overlay. I think there are issues with it, clearly with the size of the soils, and I think it's really.
What's your understanding of the benefit that would derive to your property with the removal of that overlay? What would that leave you with?
Well, it's unnecessary restriction. We can't subdivide it. I suppose I'd put that back. What's the benefit having it on it? It's kind of just odd. And also I think it would discourage people doing what James did 20 years ago. If you look at and say, well, you can only plant on these bits. Now that would discourage pioneers who say, well, we are going to plant on clay, and but it might not work. But then you'll be subject to those restrictions forever.
If the your land zone rural, isn't it?
It's general rural, yeah. So we're still subject to all of those restrictions. And it's not about the wine either. The wine, make exceptional wine. We won the champion Pinot Noir and the biggest wine tasting in the country last year. You can make superb wine anywhere in Martinborough and anywhere here. It has the same climate and everything, but there are restrictions.
No, that's fine. I just wanted to make sure that we heard from the owner of 10 Nelson Road yesterday, and they are seeking the removal of the MSO over their property. they're also seeking a rezoning of the property from general rural to another type of zoning. That doesn't, that's not your situation though, is it?
No, no, it's,
It's fine. I don't have any.
No, he's just answered my question, but then thank you.
I just have a question of general interest actually, is 800 cases of wine on a 3.5 hectare vineyard, is that a big, is that like a large amount of wine for a small area, or is that normal?
normal. It's
How many barrels is that?
So have,
30, you know, yeah, so we only get, you get 3 or 4 tons a hectare. If it's Pinot Noir, and we're generally talking about Pinot Noir. If you plant Sauvignon Blanc, you can get 20 tons a hectare. So yeah, if you sold that in the open market, you get $4,000 a ton. So it's $40,000. It's not.
that's a pretty good sort of production.
It's
Yeah.
well,
I don't know.
it's 10 tons, and it's yes, it's
Is that good for that amount of land, or it's purely interest?
no, not really. Well, it depends. It's all the only really way to make money is to make ultra premium quality wine at that. If you're selling grapes, you would lose money, quite a lot of money. So, and anyone who says otherwise is
Yeah. No, I'm just interested to see.
Mr. Mackay will probably be doing site visits in the Martinborough area, so you probably don't need to come onto your property, but if you see some people hanging around the gate,
okay.
It'll be this dodgy lot.
Empty glass.
With an empty glass.
that'll be us.
Yeah.
So the procedure from now is that at the end of today, we'll adjourn the hearing. The officers will have an opportunity, having listened to your submission, to file a right to reply. And we'll receive that, as I said, in about 15 working days' time. And then the panel will meet to deliberate, but we won't issue our decisions until the end of the entire process, which will be after May next year.
Right. So we won't know until right.
We're going to release all our decisions together so that they can be considered holistically.
Well, thank you for your time.
Thank you for
Thank
coming
you.
in.
Cheers.
Mr. and Mrs. Broom. We'll defer our morning tea to hear from you, and we'll have the morning tea break after your presentation.
Which ones are, oh, you've written,
Yes, copies that we got electronic copies yesterday.
okay, and did you get the appendix as well?
Oh, I don't think
And the other copy.
we might have it electronically, but not
We've got it electronically.
Yeah, but I've got a copy if you.
certainly welcome to see that. Thank you.
Up on your table.
Oh, yeah.
Say, Nigel, just. Say.
We actually did have a copy of it, but not in colour, so.
Oh, well, some of it, yes, some of it.
You'll see.
But anyway, we've got the slide.
And they'll be
down
much
for the
bigger.
screen. Yeah, yeah.
Which will be helpful. So we can go to the next slide, thanks, Ruth.
First,
Okay.
It's what?
a slight delay between when I make the when it shows up.
Okay, well, kia ora, good morning. My name is Nigel Broom, and I'm here today with my wife, Pippa, and supported by our neighbour, Mrs. Ruth Barton.
Morning.
Thank you for the opportunity to speak today. Here's what I'm going to talk through this morning. So we have lived in the rural special zone at 27 Huangaroa Road in Martinborough. Oh, sorry, yes,
Yeah.
next slide. Yes.
Sideways, yeah.
Thank you.
Yeah.
We have lived in the rural special zone at 27 Huangaroa Road in Martinborough for 23 years. Our neighbours, Tim and Ruth Barton, have lived next door at 35 Huangaroa Road for 19 years. We made a conscious decision to live in the rural zone on the edge of town so that we could enjoy all that rural living offers. Beautiful views, a quiet location, privacy, birdsong, and so on. At the same time, we happily accept the noises which come with living beside working vineyards, tractors and other machinery, frost fans, vineyard workers picking and pruning, etc. Our recent experience with council and the application of the current district plan has been poor, largely because of ambiguities in the drafting of the current plan. We want to ensure that the provisions in the new district plan are drafted clearly and unambiguously so that existing residents will avoid the stress and costs that we have faced recently, trying to protect our amenity and enjoyment of living in the rural zone. We are representing ourselves today with the support of the Bartons. Received expert planning advice and input on our presentation from Philip Percy, who is a principal planner at Kahu Environmental.
Mr. Percy's provided this track change. Yes,
That's correct.
Mr. Percy, nice segue. Mr. Percy has provided us with some wording amendments to the new rules, which we have attached as a separate document, which is Appendix 1. He has also provided some explanatory notes to support the suggested amendments. We want to ensure the amenity of existing residents is not eroded by the effects which rural produce retail activities might bring. For example, noise, reduced privacy, and disruption from traffic and large numbers of people. Our aim is to ensure that the new district plan provisions are clearly and accurately drafted to ensure certainty, effectively protect the amenity of existing residential activities in the rural zone, only permit non-primary production activities that will have no more than minor adverse effects, and control the effects of new effect generating activities through the resource consent process. This aim is consistent with the objectives and policies of the GRUS chapter, particular GRUS 02 and 07, and GRUS P2, P3, P6, P7, P8, and P9. All right, thank you, Ruth.
I'm going to ask you to quote those provisions.
I've got that.
Maybe later. I'm doing quite well. I would now like to describe an actual development taking place on our boundary. The reason for describing this development is to give the hearing panel a real-life example of activities that are attempting to be established under permitted activity rules. In May 2022, the neighbours on our northern boundary removed a large block of vines and began developing an outdoor wine and tasting venue involving significant earthworks, landscaping, construction, and the development of car parks along their driveway on our western boundary. Details of the proposed activity are on the slide now. We contacted South Wairarapa District Council to inquire what was going on, and were advised that Council had issued a certificate of compliance for the proposed activity back in December 2021. We knew nothing about this proposed activity or COC application until the work began 6 months later. Following our challenge to the legitimacy of that COC, the applicant lodged a new COC for the activity in September 2023 with some amendments. The second COC application has since been on hold pending further information for 12 months. We have spent a considerable amount of our time and money engaging expert planning and legal advisors to challenge Council's interpretation of the permitted activity rules in the current DP. Work continues on site, including the construction of a 2-metre high solid paling boundary fence on our northern border, a fence much more akin to urban infrastructure. We have significant concerns about the noise generated by the number of people, traffic, and amplified music on site. These sounds are very different to the rural sounds of animals and farm machinery. We remain convinced that the proposed activity will not meet the permitted activity
standards under the current district plan. The last 2 years have been very stressful for us. We have incurred costs for professional advisors of over $16,000. We consider that the nature and scale of the proposed activity and its impact on our amenity and enjoyment as neighbours should have triggered some kind of resource consent process involving our input. So our submissions today seek to improve the new district plan in order to clarify the provisions relating to non-primary production and non-residential activities, including rural produce retail, in the general rural zone, particularly where there are existing neighbouring residential activities, so as to protect the amenity of existing residents living within the general rural zone, and also ensure that investments in developments can be initiated with confidence. Next slide, please, Ruth. This slide shows the proximity of the proposed activity in relation to the neighbouring properties, including ours and the Bartons. Yeah.
I'll be the pointer.
Get my
Shout for the cables.
lovely assistant.
Yeah, do you want to think your?
Yeah, so, well, I would like to point out our property and the Bartons.
So in this slide, this is Huangaroa Road here. And our property is here, receiver 3. The Bartons live here at 35. So this is Bartons here and us here.
The development is in yellow.
Yeah, so this is the site where they have building the outdoor wine tasting venue. And you can see in this picture, that's the progress that has been made.
And also perhaps point out the road access.
Yes,
Yeah.
Road access goes through
The property is, they drive down this long, narrow drive here between our properties and this property to access site. So cars will come down here, there's parking along here, and there's a turning bay at the top for exit, which we'll explain shortly.
The parking, sorry, is along.
So there are 11 car parks located along this driveway, so cars will drive in, but because the driveway is not very wide, the way the traffic flow has to work is the cars will have to reverse. So this is a lot of traffic movement, reverse, come up here, go round a turning bay and then exit back to Wairarapa Road. So there's a lot of traffic movement.
The parking's on the left-hand side of the driveway.
On the Alstone side, parking, yes.
Do you share that drive with that?
No, this is their access because this is their whole property here. So the access here is that our driveway is here.
What's that building on their property that's already existing?
This is Alstone.
On their property.
It's their house. Here, this is their property.
Yeah, what is that?
So that is it's a accommodation.
2-bedroom.
Yeah, sort of a 2-bedroom property that they either put on Airbnb or sometimes
they don't live on it.
Yeah. They don't live there permanently.
And they're not manufacturing they're not producing their wine on site?
No, they don't produce the wine.
They didn't want to put their new development in front of the house because they didn't want it to.
They didn't want to
on themselves.
Coach on their views.
And they wanted to put it in front of Nigel instead.
That's their house. With the red roof, is it?
Yes, so this house here.
Yeah, no, the one nearer the road. What's that land? No.
Oh, the red mark is it's a Google marking.
Don't worry about that. It's just a clause.
So Aylstone.
Ah.
It is a Google marking.
Yeah, Aylstone.
They used to use it as a bed and breakfast.
Yeah.
And Aylstone own that land.
No, so Aylstone own this. This is Aylstone here, and this is the nature.
And R2
and the Bartons own this vineyard.
Aylstones haven't objected to any of this because their families related.
Yeah.
And R2 in the top corner there on
Oh, that's Margraines.
So it's Margraine. So this is the Margraine Winery Cafe on the corner, and Margraine owners live here. House.
Okay.
So the only other thing, the blue line on the picture on the left obviously identifies the land area available.
Yeah.
And I just wanted to make the point that the activity could have been positioned further away from our northern boundary, given the land that is available for use.
We don't want to focus too much on this
Yes.
No,
I-
no, we appreciate that.
Totally
Just
aware
a
of that.
live example.
It's not, well, hang on, let me just finish. It's not our role to litigate on the lawfulness of either of the certificate applications.
Correct.
Yeah.
And you're explaining this as an example as to why you want changes to the activity status and rules.
Yes, that's correct.
Under GRZ R11.
Yes.
Can I just ask a question? Because I might have a conflict of interest here because I'm the alcohol licensing chair in South Wairarapa. So do they have a license?
Not yet. They haven't applied.
Can I excuse myself then with mishearing?
Yes, indeed.
This?
Yes.
Yeah.
So there's enough of us left.
Yes, yeah.
No
problem. Thanks, Alison.
No, they've still got to do that. Yeah.
Thank you for that background. I will treat it as.
Glass of wine.
Yeah. Treat that as the context.
Yes.
Yes.
That it's meant to be an example only.
Yeah. Just a real live example of what can happen. Yeah.
And so, well, I will quickly go through, there is a couple of other visuals. So the plans in this slide show the scale of the proposed activity surrounding our property, which I'm going to talk about scale in a minute. Pippa will, so note that the buildings, if you use the other slide, it's probably easier because it's slightly bigger. There are two caravans, which are up a bit, those two. This is one. This is another one. One's food and one's wine. And then there's a permanent ablution block.
Yeah. So 1, 2, 3.
So the buildings are only a small area compared to the overall area of land used for the activity, which includes decks, pergolas, seating pods, grassed areas and landscaping. And also note the 11 angle car parks along the driveway, Pip has alluded to in the previous slide, and the traffic flow, which requires all vehicles to use the turning bay to exit the venture, which you can see there on the left-hand side. On both of them, in fact. Okay, next slide, please.
And that's our house.
Oh, yes. And now here is a short video. Not there. Okay, not a problem. Anyway, there was a video which only goes for about 20 seconds and it just demonstrates the total silence, that we experience every day.
If you've got the Dropbox version, it's there.
It's not a game breaker.
Is that the Dropbox
Oh, yeah,
version?
that's it.
Yeah.
Okay. Oh,
It's very quiet.
Right.
If there was sound, it would sound the same with birds.
I did sound of still.
Okay, maybe that's something that we could look at later, but effectively it's silent and all you can hear is bird song. So it's very
It's a
pleasant.
very peaceful
Very pleasant.
location.
No other ambient noise.
Oh, okay, excellent. So we're there.
Mute that, please.
Right, we can move to the next slide then.
Before you do, I'm just conscious of time. I might just let the next submitters know what our plans are. That Lucy William from Edison. Sure. Lucy, are you online? Oh,
In
yeah,
person.
a person. Oh, thank you. We're running obviously about 30 minutes late, and we'll break the morning tea after the submitter. So I suggest we'll probably be back around 11:15 as specific accommodation.
Thank you. So I'll now present our 3 submission points, which I will take as being read. However, today I'll provide more detail on the rationale for each of our proposed solutions. So the first issue is scale of activities. Section 42A report at paragraph 418 states that GRUS 11 and the definition of rural produce retail is sufficient to manage the scale of activities. We disagree. GRUS 11 restricts the building ground floor area to 40 square metres. The definition of rural produce retail limits the activity only to produce that is grown or produced on the same site. One key issue with the definition of rural produce retail is that it refers to the use of land and/or buildings, whereas the scale of activity in GRUS R11 is controlled only by building floor area. There is no control on the area of land that can be used for the activity. GRUS R11 also allows the use of structures. It does not include any size or area limit on those. None of these aspects consider any other factors that are relevant to the scale or effects of the activity, such as number of visitors, traffic in the form of cars and bikes, noise, or the total area of the site where the activity operates. Retail activity may not require a large building footprint, but could still involve a significant area of land. A good example of this is the proposed activity next door to us, where the buildings, 2 caravans and an ablution block, only total 47 square metres and are only a small portion of the area where the activity will take place, i.e. a much larger outdoor venue with decks, pergolas, grassed areas, seating pods, etc. As such, the building footprint alone is not a good proxy for the scale of an activity. Other factors, such as potential number of visitors, traffic, noise, and general nature of the activity, should also be considered. We recommend additional standards relevant to the scale of activities be added, and if present, will then trigger the need for a resource consent. The Section 42A report also recommends amending the definition of rural produce retail at page 157. These changes be as requested by Hort New Zealand. The effect of the changes is it broadens the types of activity that qualify as rural produce retail. The recommended changes will allow products produced or manufactured by the same operation elsewhere to be sold from the property, even if those products have not been grown or produced on site. There is no limitation on the type of products that can be sold. The addition of by the same operation does not make sense in the context of the definition because there is no prior reference to operation. For these reasons, we consider that the recommended changes should not be accepted. We're also concerned that the ambiguous wording of the definition of rural produce retail in GRUS R11 means that activities that are not genuinely rural produce retail activities will attempt to establish under these rules. In the example of the development occurring next to our property, the activity is claimed to be for the purpose of selling wine. However, the primary elements of the activity are entertainment and hospitality. We are very concerned that the drafting of the provisions on the proposed plan could be interpreted as allowing activities like this, when more comprehensive scrutiny through a resource consent process is actually required. Our goal is not to constrain reasonable produce retail activities, but it is to ensure the provisions don't have unintended outcomes. We therefore recommend the amendments to GRUS 11 as set out in our appendix. Next slide, please, Luke. Issue number 2, proximity to existing residential activity. Section 42A report does not address this submission point, and the GRUS rules are silent on any criteria of proximity of proposed non-primary production or non-residential activities, including rural produce retail, to existing residential activities. We consider that the close proximity of such activities to residential activities within the general rural zone should allow neighbouring residents to be part of a resource consent process, especially where the activities may have a significant impact on amenity and enjoyment. We recommend an amendment to GRUS 11, which requires resource consent with such activity proposed within 100 metres of a residential dwelling on another property. We also recommend that a condition of any such consent include a minimum setback of the proposed activity of 100 metres from the boundary of any existing residential dwelling or activity. Next slide, please. Issue number 3 is noise. We understand that our submission relating to noise will be part of a later hearing. However, we are including our submission on noise today, as set out in this slide, in the context of the other submissions we have made today, because any noise from non-primary production, non-residential and rural produce retail activities may have significant potential to impact on residential amenities, sleep and well-being due to the very low ambient day and nighttime noise levels in the general rural zone. Next slide, please. So in conclusion, our proposal serves to, 1, protect the amenity of existing residential activities in the general rural zone. 2, ensure the enjoyment of existing residents is not eroded by the effects which rural produce retail activities might bring, including noise, reduced privacy, disruption from traffic, and the impact of large numbers of people. And finally, 3, maintain the rural character and general quiet lifestyle offered in the general rural zone. Thank you for your time, and we're happy to answer questions. And we would also welcome you to visit the site, as we understand the council has not visited the site to date.
Thank you for that presentation. I'll just see if there's any questions in relation to the provisions that you've recommended with the help of Mr. Percy.
Sure.
I've got a couple I've got in mind. Working off the track change version. Changes that I immediately see are the to Roman numeral C and U, E, F, G, H, and H.
Yes.
So the aim of that is that all of those provisions must be complied with for their to retain permitted activity status. Otherwise, the resource consent would be required.
Yes, that's right. Yeah.
You think any of those provisions duplicate outcomes? Like, for example, if G, which is the setback of 100 metres, put in place, would there be a need for restrictions on the land area or the building size?
Sorry, so G's not a setback.
No, I'm sorry.
I see what you mean.
Sorry, H.
I
guess that would come down to the impact mainly of the noise and or the access to the venue. So I guess in our minds, the spirit of the rules is more around small ventures, people selling vegetables at their gate or whatever, as opposed to large scale, hospitality venues.
Yes.
And in that respect, the more rules you can put around it, the more likely you are to get the right outcome.
Based on that response, then the definition of the activity would be a critical constraint. Then,
Yes, that's right.
But that there's no ambiguity as to whether something that might involve hospitality or entertainment it comes under the umbrella of rural produce retail.
Yes, that's correct.
Have you thought about other activities other than rural produce retail that might allow for those other activities that are occurring that are occurring in the example you've given?
What do you mean, for example?
Are there any other activities in the rural zone other than rural produce that would have permitted that sort of thing?
They were going to do stargazing and have weddings.
I don't.
Yeah.
They were going to go to midnight and they took all that stuff.
I'm thinking more of commercial type activities.
Yeah.
Like retail or
we're not technical experts, you understand. So some of these questions we don't know the planning. I mean, Phil would happily, if you have a specific question on
I'm not quite sure
provision,
exactly
what you'll get, he will.
Could you just ask the question one more time?
I wondered
before I get it.
I wonder whether, putting aside the definition of rural produce retail,
Yes.
whether there were other permitted activities in the rural zone that might have supported the range of activities that are occurring in the example that you gave us.
You mean like along the road? Like at the restaurant?
Yeah, yes, are there any commercial activities permitted in the rural zone that would have?
Well, I guess yeah, okay, it's coming to me now. I think it comes down to the scale of that activity.
Yes.
And you know, to be honest, the biggest problem is noise. In all sorts of forms, music, you know, laughing,
numbers of people,
of people, doors closing, engines starting, stuff. And so to us, that is probably the criteria. And Phil would have to help us to put that into words, but
Where do you see the noise control fitting into those performance standards listed from A through to H?
Well, the noise standards are, I understand, separate. And so they are a separate item.
You're not seeking to change those?
Yes, so yes, they are different from the current noise standards and the current plan. So under the current plan, it's around, I think it's rule 4.5. It's where the permitted activity standards sit. And that does include, I think it's 4.5.2. There is a noise drafted provision relating to noise there. But as I understand the new plan, that noise is now moved into a different area of the plan. So it's not within.
Yes, I understand. I think it's probably what's categorised as a district-wide standard.
Yeah, so, and I'm not sure how it linked back in here, but I guess the point of this activity status is permitted is try to keep it at a small scale, because when it gets to something larger like what we're experiencing, you know, 68 patrons on site, you know, a large area of land right on our back doorstep that can create quite a large amount of noise with the traffic and the people, you know, we believe that should have gone down a resource consenting path, and it shouldn't be captured under the permitted activity status. Keep this narrow.
There are a number of metrics in the standards that you've suggested, 15 customers, 100 square metres for the land area, 100 litres setback, and the hours of operation 8 till Monday to Saturday. How are they being derived? I mean,
to be honest, they're our sort of, you know, we just came up with those as what we thought was a suitable numbers, suitable distances, not too much science, to be honest. But I guess, you know, 15 people are not going to generate a fraction of the noise of 60 or 70.
And the hours of operation, just general daytime hours?
Well, and I guess because Phil drafted these, I guess as well, we've had in mind, like, you know, if you're thinking about Greytown, for example, where someone might want to sell fruit on their back door, those are the kind of hours that they might want to keep. It's not necessarily just for wineries in Martinborough, you know, so if you look broadly, hours of operation would be.
And that's bearing in mind that the Tractor North start around 6 a.m. So that's still 12 hours of noise.
Except all the rural
that's
noises.
true, but that's taking into account the fact that, you know, the frost fans might be running all night long. So, you know, for people to be partying till 8 o'clock at night when the fans might start at like 10 p.m, that doesn't leave you a lot of quiet time.
Okay. Thank you for that. Unless there are any other questions, what will happen now is Mr. Horrell, who would have only seen this in the last day or two, will comment on this as part of a right of reply. And he'll take the lead from some of the questions that I'll put to you. He'll deliver that in the next 15 to 20 working days.
Okay.
And we'll reconvene to consider those as a panel as part of our deliberations. But we won't be issuing our decisions until the end of the process.
Sure.
In a holistic manner.
Yep. Excellent.
Thank you for your time.
Okay.
Thank you very much. You're allowing us to present.
Yep.
Thank you.
Enjoy your morning tea.
Just for those that have just arrived during our presentation, we're running about 30 to 40 minutes late. So apologies for that. We're going to hear from Edison Shaw next after our morning tea break.
Thank you.
The hearing's adjourned until 11.